Good afternoon, and welcome to this panel, Plastic Pollution in International Law. Bonjour et bienvenue à ce panel, Droit international et la pollution plastique. I'm Una Fitzgerald, President of the International Law Association of Canada, ILA Canada, and Senior Fellow with the Human Rights Research and Education Center of the University of Ottawa. Besides doing law, international law, I also make artistic assemblages from waste materials while reflecting on international human rights and environmental law. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, let me begin by acknowledging the traditional territories of Indigenous peoples. We are meeting virtually across Canada and the world, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters called Canada today. Nous sommes reconnaissants de vivre, d'apprendre de cette terre et d'en profiter. Et nous nous engageons à la décolonisation dans nos vies personnelles, nos entreprises, nos organisations, nos écoles et dans nos communautés. Les engagements que nous prenons dans cette reconnaissance des terres doivent être activement poursuivis et s'accompagnent de la conviction que la décolonisation commence par la réconciliation avec tous les peuples autochtones, y compris les Premières Nations, les Inuits et les Métis. Pour que la réconciliation soit couronnée de succès, nous devons continuer d'approfondir les façons dont nous écoutons les peuples autochtones en tirant des leçons et les soutenant en ce qui concerne leur résilience, leur résistance et leur autodétermination. The International Law Association is the Canadian branch of the International Law Association, based in London, England, and founded in Brussels, Belgium in 1873. With over 4,500 members worldwide, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. Comprised of legal scholars, legal practitioners, students, and policymakers, the ILA Global Network and its regional and national branches contribute to the work of ILA research committees on important topics of international law. They also hold biennial conferences, the next one being in Athens, Greece this June, and organize panels and workshops on a wide range of international law topics, such as this one on international law and plastic pollution. Charlesworth and Larkin suggested that to understand how international law works, it's useful to look at it from a perverse perspective. Instead of focusing on what environmental and human rights protections international law provides, they write, we could begin from the opposite end and examine what international law has to offer to the person who wants to pollute the environment or violate human rights. Try gathering plastic debris on a beach or roadside. The winds and the waves keep bringing more garbage to your feet. Collection is a Sisyphean task. Once collected, you still must wonder, where does this garbage go? Will it end up back in the sea or drifting across the landscape? Wherever you live on this planet, you are surrounded by plastic garbage. Entangled with plastic waste, living in the plastico-anthropocene, we see that international law offers full protection to those who produce plastic, regardless of environmental and human rights impacts. International law has allowed plastic producers to flourish without having to pay for the environmental and human rights costs of their products, treating these as externalities borne by all of us. Collectively, we have become a consume and discard global society of garbage makers, where burdens are inequitably spread, especially to those least responsible and most vulnerable. This is what this treaty-making process aims to address. In the margins of the UNEP Intergovernmental Negotiating Committee on Plastic Pollution, INC4, As negotiators gather in Ottawa, this panel is exploring international environmental and human rights law developments relevant to drafting a binding international agreement on plastic pollution. We have 6 amazing panelists today. Due to unforeseen circumstances, Eleanor de Anzizo had to withdraw last night, unfortunately. It's my pleasure to introduce each of the speakers to you briefly. First of all, Irina Buga. Dr. Irina Buga is a senior attorney in international dispute settlement at droit, Blackstone, Westbrook in the Netherlands. She is also advising the ocean cleanup on international law matters. She previously held positions at the Netherlands Institute of Law of the Sea and International Court of Justice. Melissa Glory, and Irina will talk about incorporating an effective international obligation for remediation of oceanic legacy plastic pollution to the Global Plastics Treaty. Melissa Glory is next. Melissa is a lawyer and law reform manager with EcoJustice Canada. In addition to her role at EcoJustice, she has worked on various organizations to advance environmental and social justice issues over the past decade. These include founding a non-profit organization, Waste Free Edmonton, which successfully advocated for a single-use bylaw in Edmonton. Melissa also recently obtained her Master's of Laws degree focused on decolonizing settler environmental law. Next, we have Alexander. Oh, and sorry, I just want to mention what Melissa will be talking about. She'll be advocating for an ambitious global plastics treaty and accompanying domestic measures to address plastic pollution. Next, we have Dr. Alexander Harrington, who is a lecturer in law at Lancaster University Law School, chair of the IUCN World Commission on Environmental Law Agreement on Plastic Pollution Task Force, and member of ILA Canada and ILA Colombia. Alexandra will be talking about the Plastics Treaty, regime convergence, and regulation of plastics producers and harms. Next, we have Dr. Sabah Khan, who is a lawyer and Director General for Quebec and Atlantic Canada at the David Suzuki Foundation, where she also leads the National Climate Change Governance Portfolio. A member of the World Commission on Environmental Law and the Barreau de Quebec, Dr. Khan has held a number of advisory appointments on trade and environment. Next, we have Dr. Sabah Khan. Let me go back. We'll be talking about plastic as the latest frontier of international environmental law, understanding the potential scope and limitations of a global plastics treaty. Next, we turn to Dr. Sarah Sek, who is the Yogis and Keddy Chair in Human Rights Law and Director of the Marine and Environmental Law Institute at Dalhousie University's Schulich School of Law. And Sarah will be giving reflections from the development of training materials for UNEP, coordinating body on the seas of East Asia, or COBSEA, on a human rights-based approach to plastics value chains. And last but not least, we have John Solorzano. John is a counsel and co-head of the Environmental Social Governance ESG practice for Vincent and Elkins in Southern California. John advises clients on securities disclosure, governance, sustainability, and compliance matters. Prior to VNE, John spent 8 years at the Clorox Company, a multinational consumer packaged goods company, CPG. There, he led shareholder and NGO engagement on ESG topics, particularly on plastics matters, helped develop Clorox's strategy around plastics reduction goals, reporting, and led venture and M&A processes around more circular solutions. John brings unique real-world perspectives to the plastics regulatory discussion, having worked with a major branded company facing pressures related to plastics. So those are our amazing panelists. And we'll be conducting this panel as a fireside chat because it's still a little chilly here in Ottawa, based on a series of questions. So I will be calling on the speakers individually, but if I miss one of you, just raise your hand, use the raise hand function, and I'll bring you into the discussion. If the audience has any questions, please put them in the Q&A, and we will try to address them during the panel and towards the end. Thank you very much. So with that, let's start off with our, oh, and I should say, because this is a negotiation, we know there's there may be some interruptions and difficulties we have, but please bear with us. These are all very busy people who really do care about this issue and are actively contributing to at this time. And so we're very grateful that you're taking time to discuss this with us and to share this information with a broader audience. And as I say, a very global audience of participants today. So first of all, I'd like to ask you a little personal question. I told you about my personal background a bit, but tell me about your connection to this issue, and use a relevant aspect of your bioinformation to frame your interest and priorities. So I'm going to start with you, John.
Yeah, well, thanks for having me. It's great to speak with everybody here. So I have perhaps a different perspective than a lot of folks who are listening in here. Having spent a number of years, I was in-house counsel at the Clorox company prior to leading ESG at Vincent & Elkins. You know, I certainly kind of worked within the packaging space, if you will, but also I come at the world through the lens of like, how do branded consumer companies think about some of the risks facing them? Particularly, I would just note that CPG companies are hyper aware of the plastics waste issues and the reputational issues associated with that, and also potentially the impending regulations that may impact their business. So it's not something that you know, I would say industry is kind of blind to or putting their head in the sand. However, I think that, you know, their perspective is probably coming at it from a very different viewpoint on what the regulations could impact, how they could impact them, and some of the real world applications of, you know, maybe a decrease in the use of virgin plastics, et cetera. I'm happy to kind of talk about all of the things that CPG companies have been doing for years, because I know that they've been really focused on this, and obviously probably not enough. I mean, we're facing a crisis, but there are some real sort of tensions in the system that I just want to be mindful of as we're thinking about, you know, developing a treaty here, because as we all know, plastics serve a very vital need within kind of the world's economy and providing safe products and food freshness and potentially, you know, diminution of, say, food waste, which is itself a massive climate impact. So I'm not here to defend industry. I'm here to kind of give the perspective of how industry is affected by this. One thing I would also just say in my new role at Vincent & Elkins, you know, I support companies in all sectors, including oil and gas. And so I would just say that some of my clients are impacted potentially from any decrease in the use of their oil, for instance, becoming a virgin plastic in due course. So I think that there are some downstream or some risks that a lot of companies throughout the plastics value chain haven't even fully appreciated yet. And so I think there'll be a lot of interest within private industry as to how this treaty is going to kind of play out. So that's the perspective that I'll be bringing here, and really fascinated discussion. And you know, I'm very passionate about plastics in a lot of ways. Oh, just one last thing I would also note. When I was at Clorox, I led shareholder engagement, which meant I was leading investment discussions with the large institutional investors who have positions, economic positions in every major company in the world. And this is a hyper-focused area for those large institutional investors as well. A lot of questions would be coming from BlackRock and Vanguard, who frankly hold 10, 20% of every company in America or in the world. And they view these as existential risks to the viability of some of these companies. And so there's a lot of pressure on the companies, both from the consumer side, from the regulatory side, from their shareholders, and wanting to make good, because there are potential economic repercussions if they're not thinking about this thoughtfully. So thanks for having me, and I'm looking forward to this discussion.
Thanks very much, John. And it is a very, very valuable contribution to this discussion, because that certainly is a big part of the negotiations. When you have, you know, oil producing countries, everyone's concerned about their economies too. So these issues are all on the table in the discussions. May I turn to Sabar next? Thank you.
Thank you, Una. Just want to say it's a pleasure to be with you all today. So as a lawyer and a legal researcher, I've been working on the intersection of environment, labor, and trade for well over 15 years now on electronic waste, plastic waste, chemicals as well, specializing mostly on the chemicals and waste treaties, WTO law as well, and various regional trade agreements, NAFTA in particular. So at the David Suzuki Foundation, I lead our international legal work in these areas. And right now I'm leading our delegation's work as observers to the INC. Started following that also early on in the process. So what really interests me in this treaty is the opportunity, I mean, mainly that it presents in treaty design. It's the first multilateral environmental agreement to be negotiated since the UN recognized the universal right to healthy environment and as a fundamental human right. And my aspiration is to see a reflection of that in treaty substance and in procedure. I feel this is a really rare and unique opportunity that we have to discipline the fossil fuel industry and its interconnectedness to, petrochemical and plastic subsidiaries under an MEA, which has been impossible to date. And at the same time, centralize people, human rights, and indigenous rights. And it's a very intersectional treaty. It doesn't fall squarely, into being a multilateral environmental agreement because of the substantial public health dimension as well. John mentioned safety in food packaging. And so, we hear on one side that discourse about, industry saying that plastics are necessary for that. At the same time, we see health scientists and physicians coming to us about, the hazardous chemicals that are contained in food packaging. So there we see that there is a risk actually in keeping on using plastics in food packaging and such. The other thing I want to point out is that, we have a lot of stakeholders. I mean, to date, it was encouraging to see that member states want to get right into the substance of it. And we see some people just wanting to focus on recycling and waste. And I think it's critical because the recycling and waste industries in many countries, are informal. It's a human rights issue. So recycling and waste have to be there, but we really have to go to the source of the problem. Under the Paris Agreement, we have that, the last decision that talked about transitioning away from fossil fuels. And we see that as we go towards decarbonization, most oil and gas companies are looking to plastics and petrochemicals for their growth. So it's sort of, it counters the Paris Agreement objectives to see this growth in plastics. It counters the right to healthy environment. And so I guess that's my hope is that we will innovate through this treaty and be more creative in its design. I guess I'll leave it there for now. Thanks.
Thanks so much, Sabah. Over to you, Sarah.
Okay, thank you very much for including me in this session, Una, and I'm looking forward to learning from everyone else's comments. I came to this issue after a fairly long history of working on business and human rights issues, and in particular in relation to environmental issues before there was recognition of the right to a clean, healthy, and sustainable environment. And after having done quite a bit of work in relation to extractive industries, in teaching and research, moving into climate, a few years ago, I was approached by the UN Environment Program's coordinating body of the Seas of East Asia to assist in the development of training materials on a human rights-based approach to the plastic value chain, and to do this in collaboration with groups in the region, so with WWF in the Philippines and the Indonesian Business Council for Sustainable Development. And we did this during COVID, online, a lot of things going on. But it was fascinating for me because I had not really turned my attention to plastics before then. And I think there is so much to learn from the plastics problem and from solutions that are relevant, I think, to how we think about other treaties and other initiatives. I would certainly align with a lot of what Sabah said about the importance of the human rights-based approach, the potential now that there has been recognition of the right to a clean, healthy, and sustainable environment, to use that to inform the treaty. And in the trainings that we designed, even though this was before the UN General Assembly recognition of the right, we actually used it as a framework in order to structure the trainings that we developed. So there was a big, focus on the substantive dimensions, but also on the procedural dimensions and the importance of attention to equity and vulnerability. And so I think absolutely the procedural dimensions of this treaty, I think, are going to be super interesting and important. The ideas of rights to information, rights to science have come out in the work of, for example, some of the special rapporteurs at the UN Human Rights Council, including on toxic substances. So I can, we'll speak more to the business and human rights dimensions later, but that's certainly how I come to the topic. And I'm very interested to see what comes out of the treaty.
Thanks so much, Sarah. Melissa, next.
Yes, thank you. I come to this issue having worked in environmental law for over a decade and doing a lot of work related to climate change, the tar sands / oil sands in northeastern Alberta and Treaty 8 territory, and recognizing the connection between plastics and plastic production and fossil fuels. The basis for plastics is petrochemicals and fossil fuels, and so that connection needs to be remembered, especially when we're talking about the context of how we address climate change. So, I come to this because it's one of the most pressing issues facing all of us right now. The connections to biodiversity loss, impact to climate, human health, Indigenous rights, pollution of air and water. Plastic is an integral issue that we need to address to advance all those other concerns and objectives. And so I also want to, like you mentioned, the Waste Free Edmonton piece. I also have, on a personal level, have always been just shocked at our ability to rely on single-use items in such a throwaway fashion and in such an unnecessary way. And Waste Free Edmonton for me was a bit of a cathartic experience to try to feel like making a difference on one of the lower hanging fruits. Obviously, it's a lot more complicated and a bigger, more complex issue than single-use plastics, but how emblematic that is of the culture that we live in and this notion that there is this a way, and that was sold to us by companies who wanted to sell plastic. A couple of decades ago, we had to convince people and help them understand what the concept of disposable throwaway culture even looked like, because that's not the way it was, several decades ago. So I come to this issue seeing the importance of tackling the plastic pollution crisis at the source, knowing that many plastics are inherently toxic, and that we know that there are chemicals out there we haven't had disclosure about what the impacts are, and that we're really playing with fire in humanity here. The implications for our health, for our right to the healthy environment are astounding, and I think we're just starting to understand what this plastic soup we live in is doing to us. We are now just absorbing back into our bodies the plastic we've put out into the environment, the impacts of microplastics being in our lungs, our brains, our blood. It's astounding, and it's incredibly scary. And we also have a lot of frontline communities that are being disproportionately impacted by plastic production, all the way down to disposal. And so it's definitely a rights-based issue as well. And so I come to this because I'm passionate about environmental protection, human health, and Indigenous rights. And I also am a lawyer by trade, and so I also like to nerd out on some of the technical aspects as well. And let's talk about accountability and national plans and how we put meat on the bones and don't just leave with a piece of paper that's some nice words and some empty promises, but it's actually going to make a difference on the ground.
Thanks, Melissa. Alexandra, to you.
Of course. So I think I have the easiest answer of all, and that the name and the title of my my position at IUCN at WCL kind of gives it away. So I am involved in the agreement itself and advise a number of countries on behalf of IUCN who are involved in the negotiating process, and also have worked with the members of the task force within WCL to create legal briefs, to create advisory opinions and information, et cetera, that go to all of the negotiators and that go to other IGOs and NGOs, et cetera. So in that way, it is quite easy. All of this obviously builds on a very long track record of international law involvement that includes just transition focus as well as human rights focus and international organizations focus. So it is in some ways a really wonderful way of tying together all those areas of expertise in one particular field and one particular topic. And certainly I've been involved in the negotiations since before they were actually negotiations. So in the planning before INC1 up until INC1 and 2 and 3 and now 4. So to the extent possible, we'll be happy to provide insights from that. And I will apologize in advance if you hear the little WhatsApp ding going off periodically. I am getting messages back and forth from negotiators. I'll probably have to turn off my camera momentarily, but thank you for the chance to at least be here and talk about this with a different audience today. So thank you.
Great. Thank you so much, Alexandra. And last but not least, Irina.
Thank you very much. It's a pleasure to be here also against the backdrop of INC4. So in short, my connection to this issue, I mean, it stems, I guess, generally from my public international law of the sea background, but specifically from the fact that I've for many years now been part of the core pro bono team at the Brouw that regularly assists the ocean cleanup. For those who don't know it, that's a foundation that is, in short, essentially developing large-scale technologies to rid the oceans of plastic in many different areas. And in particular, in my case, I've served as their general point of contact for matters of international law, which is very exciting work. And specifically, together with João Ribeiro Bidawi, who was until recently the general counsel of the Ocean Cleanup, we're in the course of publishing a paper on incorporating the obligation to remediate, so to eliminate or clean up so-called legacy or existing plastic pollution in areas beyond national jurisdiction for the purposes of the future Global Plastics Treaty and what concretely that would entail. And that's also what I'll be talking a little more about tonight. That'll be my focus. So a slightly different perspective, perhaps, but with a focus on the high seas.
Great. Thanks so much for that, Irina. Okay, let's move to the second question where we get more into the treaty and why we need a treaty. So what is the state of plastic pollution and precursor chemical regulation nationally and internationally? And what are the gaps that created the need for this treaty-making process? And I'd like to start off with you, Sabah, and then go to John, and I'll go through the list.
Thanks for the question. So when it comes to chemicals regulation, if we go back, to when petrochemical-based products started first entering the market, the 40s, the 50s, there was no chemical regulation. And so when, chemicals regulation appeared in the mid-70s, what happened was that it got off to a false start because all those chemicals that were there in the market, just were grandfathered into the market. So they didn't have to be proven to be safe or not. And what we saw was gradually, as the evidence becomes clear on, certain hazardous chemicals, they get taken off the market. But then they're replaced by another substitute, which has oftentimes, they'll take out one molecule and replace it with another, and then you have equally hazardous properties. And so chemicals regulation by far in all these jurisdictions, except for maybe the EU, where there's, starting to be class-based control of chemicals, is really substance by substance. And we've always been catching up. Regulators have always been trying to catch up to industry because regulators don't have the same resources, when it comes to testing and whatnot. And so a lot of the times when, chemicals data, safety data is actually industry driven, right? Those studies. So it's a very gray area. There isn't a lot of regulation when it comes to the petrochemicals that are inside plastics. There are no disclosure obligations, for instance, when it comes to the polymers that are on the market, what kind of chemicals are going in there. And often from a health perspective, what we see is really unrealistic standards when it comes to the evidence for demonstrating links between toxic substances and human health. Because chemicals, are ubiquitous in the environment, it's that, that argument always arises that you can't prove it to be linked to one specific source. So PFASs are, one example of that. And when it comes to the international setting, chemicals are barely regulated internationally. We know that there are over 16,000 chemicals used in plastics. We know that 4,200 of them are, highly hazardous. They're known. The fact that thousands of chemicals used in plastics are, well evidenced and understood to pose hazards to human health and the environment. It's problematic in the sense that, we don't have information on what kind of products are containing these substances. So I think it's only about 6% of chemicals that are used in plastics that are regulated internationally. When you look at our chemicals and waste treaties as well, they're very limited in scope. And so when it comes to this treaty, I mean, all plastics have chemicals. We're seeing there's a major public health crisis associated to these chemicals, neurological, respiratory, cardiovascular disorders, especially, Indigenous peoples, waste pickers, children, vulnerable groups. There's an environmental injustice side to it too. If you even just take into consideration Turtle Island or North America, you go to the south and we have Cancer Alley in Louisiana, which is the petrochemical cluster there. It's rapidly expanding, and it's in the heart of African American communities who are mostly exposed to that pollution. You go further up north, there's Sarnia, and I'm sure Melissa can speak more about this. This organization is working with the Aamjiwnaang First Nation, Chemical Valley, also another petrochemical cluster, the impacts being felt on Indigenous peoples. The Inuit Circumpolar Council has been very vocal on this plastics treaty because you go further up north in Inuit Nunangut, and there you see, levels of persistent organic pollutants in the population that are 2 to 11 times higher than in the general population. And we know that the Arctic Ocean has the ocean that has some of the highest levels of microplastic. So really, this is an environmental justice issue. The fact that we have to maintain some sort of control restriction of chemicals in this treaty, and we do need to keep an approach that is multilateral. When China, for instance, when it comes to plastic waste, when China imposed a ban on plastic waste, we saw all that plastic waste, that would normally go from the US, Canada, the European Union, Australia, that was going to China, it was being shifted to other jurisdictions. And so with chemicals, it's the same situation. And this problem shifting, to avoid that, we really need a multilateral approach.
Thanks, Stella. John, would you like to add your thoughts on this question of gaps?
Yeah, certainly. I could probably speak a little bit more to the pollution side than the chemical side. I mean, from a veteran in consumer packaged good industry, I mean, what drove a lot of sort of the industry's concern was the perception issues from consumers, the reputational issues from consumers, and I think that's frankly driving a lot of maybe some of the, and we'll get into it later, some of the greenwashing allegations that you're seeing around, products being recyclable. We were hyper-focused on how the consumers would react to the product offerings that we gave and the value proposition that we were providing consumers. And that's where plastic becomes a very viable option because it's durable, it's cheap, it's lightweight. All of the things that make it great on the front end also make it terrible on the back end when it comes to waste. And that's something that, I think that industry is very concerned about. There certainly are some consumers that are also concerned, certainly, with the product safety and the chemicals within the resins themselves. And we had a kind of broad spectrum of brands, and different consumers had a very different perspective on things. So, for instance, one of our brands was the Burt's Bees, which makes kind of naturally positioned lip balms and skincare. Very interested consumer in those types of considerations, and so it was something that we were very thoughtful about how we wanted to talk to the consumer. On the other end, we also owned the Glad trash bag company, also very much plastics focused, also very much focused on how consumers were perceiving product efficacy, strength, lightweightness, odor control. I'm just trying to say all of this is that the consumer lens through which sort of the packaging industry is kind of viewing these things is driving a lot of what you're seeing in the market, and it is a lot of it's based on cost and performance, and there are some inherent challenges with sort of deviating from those cost and performance metrics that consumers come to expect. We spent a lot of time within industry trying to test different models, and you know, we hear a lot of things like consumers really care significantly about you know, health and safety or sustainability, yet they might say that, but when it would come to actually purchasing, that wasn't necessarily what we would always see. And so you would actually see there's a lot of price sensitivity, and so that's another reason why you're continuing to see kind of the incumbent products continue to be polluting the environment. You know, what I would then sort of say as a corollary, which is why I think, you know, this treaty is continuing to come into effect, or the need for it, is what, at least within industry, there's not a lot. I mean, there's basically no regulation now, nationally or internationally, when it comes to waste. And so you're seeing some voluntary type of disclosures, voluntary types of commitments around reduction. That's clearly insufficient. And, you know, I'm just a little concerned that a lot of companies all the way up and down the value chain are making these types of voluntary commitments, and there's no teeth there. And so that's where I think the international regulatory environment may kind of drive some of this, but I think it needs to be done prudently and thoughtfully. So that's, well, I'll leave that there, but that's kind of the perspective I would just give from industry, because there's a very consumer focused mindset. And, you know, I would just say that there's at least a perception that the science is unsettled. And to your point, Saba, there's a lot of things out there that are doing really bad things for us, and it's hard to pinpoint any single one of them. And I'm not trying to defend any particular part of it, but until that science becomes more settled or more clear, and this is the perspective anyway, it's hard to deviate from the tried and true cheaper resins, the cheaper products that are kind of what we've been using in, like, you know, the regulatory bodies have not been regulating those things. And so if those chemicals are ending up in the plastics that we're using for packaging, for, you know, PET or HDPE or whatever it may be, that is what it is, and that's the cheaper solution that the industry is being provided, and that's what they're using. That may be a very good opportunity to change.
Thanks, John. Melissa, I see you have your hand up. You want to go next?
Sure, yeah, and I think, you know, it's just the language I'm hearing a lot there is the consumer and value, and very like around consumption and the economic framing. And I think the more we don't think about them as people, they're people, right? They're not just consumers, they are actual people who are being exposed to toxic chemicals and whose health is at risk. And so I think we need to be thinking about what are the impacts to people, and thinking about human rights, human health as a framing. And I get that we live in a world where the economy is often driving conversations, but I think that's part of the problem, that what has gotten us to this point is that we are so focused on continuing to produce and consume for the economy's sake and for profit of plastic producers. That is part of what has gotten us into this situation. And so when you talk about chemicals, you know, we need to be looking at what are the chemicals that we're putting out into the environment. What are the implications? What are the impacts on people, on their health, on their rights? That should be the focus and the center of things. Without a healthy environment, without our healthy bodies, we are nothing. The economy will not matter if we cannot, you know, sustain ourselves and the rest of the species that we live with on this earth. And so I think it's just really important to think about the framing that we're bringing to this, and the need to shift maybe how we're looking at this problem. And I would also say I've been on many calls with very, you know, educated scientists who are well accredited, who would dispute that there's any unsettledness about the impacts of plastics. If anything, we don't have full disclosure on the full impact. And we need to have that in this treaty. We need to have full disclosure and transparency about chemicals and their impacts. But I think and maybe there's a perception out there from some people that we don't necessarily know, but that's not because the science isn't there. That might be for various other reasons, but we need industry and others to be working together to put forward and support what the scientists are saying, and having a treaty based in science and Indigenous knowledge in science that is transparent so people know what they're putting in their bodies.
Thanks, Melissa. I see Sarah's got a hand up and John wants to make a response, I think, but I'll go with Sarah first.
Thanks. Just wanted to say that as I've been doing presentations of some of the work that I did on the human rights-based approach to the plastics value chain, I've been following the work of the Stockholm Resilience Center. And at a certain point, they do work on the 9 planetary boundaries and, compiling scientific studies to figure out has, humanity exceeded certain boundaries or not. And when I was initially looking at it, climate change has been very central in people's minds, and it was clear that they had compiled the evidence, and you could see in climate was one of the concerning ones. But a few years ago, what they called novel entities, which is where plastics, microplastics, nanoplastics, and chemicals fit in, they had sort of we're not sure, we haven't put this together. And then in the last year, they put it together, and it's off the charts. Climate looks like an insignificant problem by comparison to the way in which the Stockholm Resilience Center has categorized the novel entities problem. And yet at the same time, I think there's a question of how do we understand what the problem is and what the science is, right? Because some of this originated in observations about the marine environment and the challenges where I think the science was more obvious. But the headlines, again, in presentations, I draw upon sort of headlines from recent Guardian articles, and the articles would be, okay, there are plastics in, the placenta, in people's blood, in their brain, and this and that. But it is causing these diseases. Maybe those studies haven't been done or haven't been released. But the key question, and I think this points to why we need the treaty, is because all of those things should not have been released without somebody doing the studies first. And industry needs to take more responsibility for actually doing the studies and releasing the studies. And this also goes into the approaches that are going to be taken in the treaty to new plastic, alternates. And I haven't got the right sort of terminology here, right? But the idea of substitution. We also have a problem if, and when we see this in sort of the climate action, context, right? Any green energy is a good thing because it's going to, reduce emissions. Well, maybe it's not. You can't switch from one problem to another without doing the proper studies, without involving people in decision-making, without being respectful of human rights. And I think that is really why a treaty is needed, if the treaty actually delivers on those dimensions, on the rights to information, the rights to science, the responsibility to do the science, to do product design, and all of those things, as well as remedy for harm, which is something we'll come back to.
Okay, thank you for that, Sarah. And yeah, we'll get into more of those issues about extended producer responsibilities and all those issues as we go through this this session. John, if you can retort quite quickly, because I also want to hear from everyone.
Yeah, no, I'll be very quick. And I just want to say, I actually fully agree with both of what Melissa and Sarah said. I was just giving the perspective of how industry is thinking about these things, and their view is, if the science was settled, then the regulations would already be there, and then we wouldn't use those. And so this is why I actually think that this is really important, because until that happens, no company, and obviously private industry is driving a lot of this, they're not going to unilaterally disadvantage themselves versus their competitors. And so you almost need regulation to kind of drive that behavior change. And so that's one of the challenges here, which is why, I would say a lot of people in the industry don't love to see more regulations, but I think regulation is the only way to move the needle, because you're not going to get people to unilaterally put themselves in a position that is disadvantaged than their competitors. And so that's just the reality of, capitalism, unfortunately.
Yeah, so you end up with you try to get a level playing field.
Right.
Same regulation, yeah. Which is going to be important for all kinds of issues in this whole treaty because of the fact that these products flow across borders, etc. We'll talk about all of these complex issues. I'm going to turn to Irina now, because you had some thoughts, I think, on gaps in remediation and technology.
Yeah, so as mentioned, also in view of the time, I'll focus my response only on the slightly different angle, but related, of course, on the perspective of remediation of legacy plastic pollution on the high seas. I don't think I need to explain much as to why that's a major problem to this crowd. Suffice it to say, we have sufficient evidence to know legacy plastic pollution, so existing plastic pollution in the oceans, carries major environmental, human health, socioeconomic implications, can even exacerbate the process of climate change. So we clearly have the why, but I think the next question here is, what are the gaps that created the need for this treaty making process when it comes to legacy plastic pollution on the high seas? And in short, this comes from the fact that the existing legal framework is essentially a patchwork of broad, open-ended obligations to mitigate plastic pollution in areas beyond national jurisdiction, which includes cleaning up that plastic pollution, but specificity is lacking. And what is important to note for the treaty negotiations is that when you look at some of the key conventions out there, there's a convergence across these various conventions, like the UN Convention on the Law of the Sea and many others, when it comes to the obligation to tackle existing plastic pollution. So when it comes not only to the obligation to prevent it, but also to reduce existing plastic pollution, also in areas beyond national jurisdiction, and positive obligations to adopt appropriate rules to that effect. So in other words, the obligation is not new, and we're building on what already exists. But the issue is that the existing framework isn't good enough, not just because you have these non-specific obligations, but also because we see harmonization issues and problems of fragmentation between all these different treaty regimes. And finally, and that's something that I'd like to emphasize, I think it also reflects a lack of these gaps, these regulatory and legal gaps, also reflect a lack of clarity as to how to approach the problem, both from a legal or theoretical and from a practical perspective. And by that, I mean, how do you deal, for example, with issues of attribution and go about assigning responsibility under the traditional state responsibility regime? And is that even the way to go? I would argue it is not, given also the practical problems that would entail. Or should you rather turn to a forward-looking model of collective responsibility in recognition of the nature and challenges involved in the specific challenges involved in dealing with plastic pollution in areas beyond jurisdiction? And I'll stop there, adding only that I'll say something about this later. This is particularly the case when it comes to financing cleanup operations and setting out specific targets or scientific and technological methods for the removal or reduction of plastic pollution. I'll stop there.
Thanks very much, Irina. I think we can move to the third question now. We still have quite a few to go through. And that's the one on stakeholders and rights holders, just to kind of put them all on the table. What can we learn, I guess, from other treaty processes? How do we identify and deal appropriately with the various stakeholders on this kind of an issue, and how do we deal with rights holders? So I'd like Melissa to lead off on that. I'll go to John, Sabah, and then Sarah, and anyone else.
Thanks for that important question. And I think, this process, what's called INC4, the fourth round of negotiations for the Global Plastic Treaty, has really highlighted issues around rights holders, specifically that Indigenous peoples who are not just stakeholders, but unfortunately they have been treated as such in many ways in this process. And we've seen this. This isn't, the first time that this has been an issue in other international processes. This happened time and time again. But in this particular instance, it has been very challenging for Indigenous peoples to have a say in the process. Indigenous peoples are sovereign nations. I'm sitting here on unceded traditional territories of the Anishinaabe Algonquin peoples, and they're not being treated, their sovereign authority and their rights are not being respected the way that they should be, given that this is their land, this is their territories. They do not have a seat as equal decision makers. They're not treated on a nation-to-nation basis with the other states. They have, in order to get, their voice heard, to have their rights and interests centered in the process, they have to seek the 2-minute intervention process through that's available, which is not really a lottery, but it kind of is. And so for them to get even 2 minutes on the floor with all the nation states from around the world is a maybe for maybe one Indigenous person during a plenary process. So that's a really significant issue. I've been, meeting with many people from across the world, Indigenous people from across the world, who are all facing the same struggle, where they are the ones who are most impacted by plastic pollution, yet they are struggling to have their voices heard in these international processes. And so we're seeing them, having side events to try to get the message out. And so, for example, we are here with Aamjiwnaang First Nation, Saba mentioned Sarnia, so in northeastern Ontario, and it's termed Chemical Valley. One of the UN special rapporteurs went and visited, and if you read the document, it's scathing, calling them an environmental sacrifice zone. The amount of industry that they have, the amount of pollution that is produced from these facilities is exorbitant and would not happen in wealthy white neighborhoods. It's a clear example of environmental injustice and environmental racism. They have just recently, there was a huge spike of benzene, which is a known carcinogen in their communities. Hearing firsthand from the people here who are worried about their kids, their partners, who have, schools and playgrounds across the way from a styrene producing facility. This is what's happening to them in their real life every day. Their health is at risk. They're worried about getting cancer, asthma, just other health implications in the day-to-day. And so to me, it is insane that we have a process set up where nation states come and spend days and days negotiating, and Indigenous peoples, other frontline communities as well, but especially Indigenous peoples as sovereign authorities, rights holders in these lands, to not have their voices be centered, to not be at the table as equals when they are being the ones bearing the brunt of this pollution, and putting their lives are being put at risk because of plastic pollution through the whole life cycle. It's really a concerning thing to watch, and my heart breaks seeing how much that aspect is not being centered in the process. That needs to be more central to the conversation. How are we addressing the needs of Indigenous peoples, other frontline communities, people of color, people who've been racialized and otherwise marginalized? We need to be adjusting the process so that their voices are heard and centered, and that their needs are addressed, and they are the ones helping come up with the solutions, and not just being told top down how it's going to be for them.
Thanks for that, Melissa. It's a really difficult issue with United Nations processes generally, although I guess they've worked out some better processes than others, but hopefully there'll be progress on this at the INC meetings. Is there anyone else who wants to talk about rights holders, or shall we move to Sabah? Go ahead.
Yeah, I think Melissa raises a great point. And, the other rights holders, I would say, are informal workers. At least there's a huge global workforce that works in precarious conditions. The electronic waste recycling workforce, that's also plastic related, because, doing research in Agbogbloshie in Ghana, there's plastic wires that are burned to recuperate the copper. And and there's ways that we can incorporate these rights holders into the treaty, not only as full members, but also with respect to complaint mechanisms. So if we, go back in time, like we always refer to the Paris Agreement as the most recent, but go back in time, 1919, the ILO was founded. It's the International Labor Organization. It's the only tripartite UN specialized agency. So you have members, an equal number of members of government and employers and workers that are, on the governing body and taking decisions. You also have the Committee on Freedom of Association established under the ILO in 1951, whereby any trade union, can make a complaint about a member state's or any country's violation of freedom of association directly to the committee. So, I think that over time, international environmental law, or MEAs, have become so restricted and narrow, closing compliance mechanisms to only, state parties or to secretariats. But we need to think more openly, especially when we're regulating something here where, human rights are at the center of this treaty. We heard it from the Global Waste Pickers Alliance at the very beginning. And I think that this remains one of the, fundamental flaws in the international legal order. We know that sovereignty of Indigenous peoples was denied, through the doctrine of discovery. Over time, we introduced the concept of self-determination of Indigenous peoples, but have we really, made space for that nation-to-nation equity when it comes to decision-making? I think there's so many models we can follow. The IUCN, has Indigenous peoples as full members. The Arctic Council has a different format whereby permanent participants of Arctic Indigenous peoples also exercise great influence over decision-making, which is on consensus. So, I would like to see those kinds of mechanisms, introduced in this treaty, where we're really not just, isolating it as something in the environmental field, but really centering it something that's fundamental to, uplifting the human dignity of all, which is one of the fundamental principles of the international legal order.
It would be great if if this agreement could be used to innovate in this area, as you're suggesting. Okay, just briefly, maybe we should talk a little bit about, for the benefit of the audience, about stakeholders, because it is a process that involves quite a few, and certainly industry is a piece of this, right? So maybe I'll turn to John if you'd like to talk a little bit about that aspect of it.
Yeah, and I'll try to be as quick as I can. I do want to acknowledge that, I'm going to speak about this from industry's perspective, but the rights holders that Melissa and Sabah just talked about are of critical importance. The problem that I would say is just the way that our international order is structured. Those voices get marginalized, and that probably needs to change. But we are kind of where we are right now, and so I'll just provide the perspective of the industry who the view is they are providing a product that people want, and there's almost a societal issue with the demand for convenience, the demand for kind of single use, all of those things. And so there's a provision of what people are asking for, full stop. And that is kind of what drives the whole economic system. And so, I will say from like a consumer packaged goods company's perspective, their view is we are providing consumers what they are demanding. And so I worked at a disinfecting company, for instance. In some cases, those aren't necessarily single use directly, and there are some limitations if you're providing bleach in a bottle to what you can do. There are limitations to the PCR that you can put into it, or the types of chemicals that are compatible with some of the disinfecting, which the science there may be some who will sort of debate the efficacy of the EPA approvals there, but there are just some realities around kind of chemistry around what can work with different sort of chemicals, and that is one of the limitations that's driving a lot of the choices that the consumer packaged goods companies are driving. Now, that being said, I think that there is absolutely an overuse of kind of convenience as an excuse. And so I think a lot of what's driving both CPG companies and then ultimately indirectly some of the upstream producers, the oil companies, is that fact that there is this kind of insatiable demand for this stuff that can just be kind of thrown away and made a problem somewhere else down the road. So I think that certainly needs to be addressed within this treaty, because absent kind of international norms or laws or national requirements, you're going to continue to see these behaviors from the whole value chain because they're incentivized to do so. Similarly, I mean, the people who are driving a lot of this capital allocation decision are the large institutional investors who are putting money into these companies. They will keep doing what makes them money because that is what they're incentivized to do. So until that changes or until the regulations or the litigation is that these companies are facing can expose the money to risk, they're going to continue doing it. So I just want to be realistic about what's driving a lot of this. It's not sort of kind of trying to be evil or do the wrong thing. They're actually trying to work within the rules of the game, but I think the rules of the game maybe aren't sort of structured in a way that makes sense for all of society. And that's something that I think that this type of treaty could certainly solve.
Mm-hmm. Yes, thank you very much for those comments. And also, it's really important to bear in mind how the economy functions as we try to negotiate a treaty like this, because otherwise we won't understand why states are taking certain actions, right? I mean, we need to understand these different dimensions.
Yeah.
Thank you for that. Sarah, go ahead.
Yeah, just two quick points. One is in terms of thinking about the, treaty negotiations, I believe there was a report that was released today or yesterday pointing out that the number of industry and petrochemical representatives at the negotiations absolutely dwarfs the number of many different groups. And so I think, another piece of the negotiation process is who gets in as well as who gets time and who gets whose ear, and that has been a big problem in the climate negotiations. It has been addressed in the tobacco context. And so I think there's a tricky balance between industry having important knowledge and expertise that does need to be there on some level, perhaps with this complete, overwhelming of the process by those. The other piece I just wanted to note is I completely agree with everything that was said about rights holders, but I want to sort of add that the formal workers who work in petrochemical industry contexts are also rights holders who often don't have the knowledge or the protection of their rights to health or the rights of their families and communities. And so I think it's really important to figure out how to overcome this sort of, it's good for jobs and bad for the environment dichotomy, and try instead to figure out how to see workers as rights holders with the potential to actually serve as whistleblowers who should be protected and who should be encouraged and enabled to, to pay attention to problems within their companies that are causing harms to their families and communities. And I think, again, a right to a clean, healthy, and sustainable environment frame and the work of, the Special Rapporteur on Toxics and the principles on the rights of workers to, non-toxic workplace can be really helpful in trying to overcome those problems.
Thanks for that, Sarah. Yeah, that's a really important aspect of bringing these issues together, isn't it? And it really goes into the question of transition planning. How do you address the people whose lives are very much entangled with the plastics industry or waste management, etc. It's quite a complex issue, an important one. I'm going to move to the next question where we talk about core principles. So if you go to the zero draft, there's a very long list, and I haven't noted them all down here, but a very long list of potential core principles. Hi, Alexander, you're back. Is it okay that we just move to question 4? Or
no, absolutely. That's fine. I was kind of listening in the background because I didn't want to go in and out on questions I wasn't down on the schedule for. So absolutely, definitely.
Oh, okay, all right. So what should be the core principles at the heart of the treaty? And some that I've listed are, example, prevention and remediation of plastic pollution, common but differentiated responsibilities and respective capabilities, environmental equity and justice, due diligence, circular economy, precaution, polluter pay, extended producer responsibility, human right to a healthy environment, just transition, sustainable development, ending subsidies, and the list goes on. Maybe I'll start with Irina on this one. Thank you.
Thank you. Yeah, I'm happy to mention what I'd refer to as the key environmental law principles, acknowledging, of course, that they are inherently interlinked. And I'll explain briefly how I think they connect to the notion of collective responsibility in the context of remediating legacy plastic pollution in the oceans. One is the precautionary principle, of course, which we all know, which entails that we need proactive, preemptive measures based on the best available knowledge, even if science is not yet settled on these issues. Another is the duty to prevent transboundary harm, also in areas beyond national jurisdiction. That speaks for itself. But what I should mention there is that when it comes to tackling legacy plastic pollution in the oceans, it poses lots of practical and legal challenges. For example, because legacy pollution stems from private conduct, you also have a plurality of both responsible and injured states, entailing all kinds of complicated causation exercises, to say the least, and difficult questions on compensation. So basically, to make that duty feasible to enforce when it comes to the cleanup of existing plastic pollution, for example, I'd argue we need to move towards a collective approach. As a corollary to that, you have the duty of due diligence, which is also crucial to mention, requiring states to take preventive measures and address existing damage. You also have, of course, the corresponding overlapping duty to compensate environmental harm, which accords with the polluter pays principle once damage does occur. And there I just want to mention that, and I've hinted at this previously, the law of international responsibility and liability for environmental harm, as it stands, doesn't provide sufficient specificity and entails all kinds of sort of practical conceptual issues with assigning and quantifying, for example, the duty to compensate. So once again, I think we need to move towards a collective responsibility model. Sustainable development, intergenerational equity, those can also be mentioned, basically translating into the imperative to implement long-term strategies to mitigate plastic pollution for future generations. So to wrap up, basically, if we consider these key principles, and of course there are others, I'm aware this is by no means an exhaustive list, and I'm focusing again specifically on remediation of legacy plastic. We see the need, I think, conceptually, but also practically, to move towards acknowledging the need for collective responsibility to tackle plastic pollution, particularly when it comes to remediating legacy plastic, and also in the process, as is also being discussed in the current negotiations, to take into account the notion of common but differentiated responsibilities. I'll stop there.
Thanks, Irina. Maybe I'll turn to Alexandra next, since.
Of course, absolutely. So I think this is absolutely, it's one of those areas where it is important to emphasize the issue of regime convergence that Una had mentioned. I wanted to really kind of highlight throughout this discussion today, because we see a lot of discussion points, and we actually had the negotiations last night, the first round of negotiations in a subgroup, looking at the principles and discussing which principles might be used, and whether we actually use principles or whether we keep them out, or how this would look. We hear a lot of things about the Rio Declaration, and we hear about some aspects of the Rio Declaration more than others. Certainly we hear about CBDR, and that is a very polarizing issue right now. It's very polarizing. There are many countries that maintain we shouldn't have CBDR in. There are some, obviously, who maintain it's critical. There is a stress on the inclusion of Rio 12, which relates to the idea of not using environmental regulation and environmental law that would accord with the Rio principles, at least in theory, as part of an effort to in any way promote subsidies or have other forms of trade practice that would be discriminatory. So there is that coming up as well, and it's being raised very much organically by the countries. But I think it's important for us also to remember that many of the international agreements, the MEAs, as they're called, multilateral environmental agreements in particular, do also represent a set of principles and a set of things that are common values. So we think about the UNFCCC and the Paris Agreement. We think about, especially certainly from an ICN perspective, biodiversity. So the CBD, as well as the GBF, the Global Biodiversity Framework, et cetera. And all of these things are we hope, many of us believe, will be in the preamble, but it's also important for them to be legally part of the text, to be included in the principle section themselves, and not just be something that, oh, they're in the preamble, and it's fine, it's out there. Because we know that the preamble text is obviously very powerful, but it is not the same thing as articulating the principles that are behind all of these different conventions as part of the core principles of the new, whatever we call it, Plastics Treaty, ILBI, et cetera. And we've certainly seen this coming in from the work of other entities that were created beforehand. So UNFCCC, CBD, the Basel, Rotterdam, and Stockholm conventions, the Minamata conventions, all of them have been a bit retroactive in trying to make connections with each other, with trying to establish how, yes, an environmental issue like anything having to do with pollution is very specific, but it also has many cross-cutting elements. And this is actually an opportunity. It's a very rare opportunity for us to say plastics are so cross-cutting that we do need to recognize in principles that they relate to all of these other treaty regimes as a principle, and all the principles that come in through them, and all the laws that come in through them, rather than just referencing in the preamble, being very happy and moving on. So that is certainly something that I think we don't talk about a great deal, and I like to highlight. And then I'm happy to be quiet and let Melissa speak.
Thanks, Alexandra. All right, Melissa, you'd like to go next?
I'll let my hand pressure you, Alexandra. Yeah, the reason I raised my hand is more just because I feel like what I was going to say flows directly from what Alexandra just mentioned, in terms of, I do agree, we don't want to leave it just in the preamble. We want to have substantive provisions around principles. But I would also say, even more so, to ensure that it's not just left to like the principles itself and say, okay, well, we put the polluter pays principle in there, so we're good. It needs to still be interwoven with all the other substantive provisions. So how are you bringing the polluter pays principle to life in the document? Are you creating funds or mechanisms to ensure that polluters are remediating the harm that's caused, especially to the Global South, to SIDS and others? So I think that just for me highlighted, I think most all of these principles are great and should be included, but we don't want to just stop there. We want to really bring them to life in the text itself, and the mechanisms that are implemented. Another example being like the precautionary principle. Most people would say, yeah, that's good. We want to be precautionary when it comes to our health. But then when you're setting up provisions around chemicals of concern, which chemicals you're going to eliminate, the process by which you're going to set criteria and list them in annexes, are you actually taking a precautionary approach, or are you requiring a very high level of evidence and doing it by chemical as opposed to by classes, which allows things to move forward more quickly and more meaningfully? So I would just say that is a general framing to keep in mind when we talk about these principles, which I would say most of them are very strong and important to include.
Thanks for that, Melissa. I think Sabah, you also wanted to make some comments on this.
Yeah, I mean, I'm in agreement also that, there's several of these principles that are very relevant. And we also can't forget, though, that, I mean, a single principle has multiple dimensions. We talk about intergenerational equity, but it's actually a more recent legal principle in that sense. And you can think of it as having at least 3 dimensions, when if you really want to conserve intergenerational equity, it's really about also conserving the diversity of natural resources, of the cultural base as well, conserving also the quality of the environment, so we're not passing it on into worse conditions to future generations. And then there's equitable rights of access, so procedural as well, both substantive and procedural. And, above all, I think that Melissa's right on when we talk about precautionary principle and science. If you look at our regulatory frameworks, right, risk management, it's based on risk analysis. And so whose science are we using? And when you think about Indigenous knowledge, right, are any of these principles going to be informed by Indigenous knowledge, Indigenous experience? And so I think that, there too, like we have rights of nature. We've been working with several Indigenous nations that are exploring rights of nature as a possibility. And so that, though, is also it's progressive principle, but it's also loosely defined. So really, I think that, while principles can help frame, the interpretation of the treaty, it's a complex issue because if we go from if we're only taking that Western legal lens, let's say, for this treaty, which fundamentally impacts Indigenous peoples and vulnerable communities, outside the Western world as well. And I think these are deep issues that we have to consider also. And so, we think about principles as being the most important, but perhaps procedure is the most important, right? Because if we don't put in those procedures, complaint mechanisms, then it's impossible to implement. And what we see in different MEAs is that when there are compliance systems, states are hesitant to use them because of fears of retaliation. So, and then if we also wait for compliance systems to be adopted, the Rotterdam Convention, it took 16 years to get a compliance mechanism there. We still don't have one for the Stockholm Convention. So really, I think the emphasis should be as much on procedure as on principles. Thanks.
Thanks for that, Sabah. That was great points. Sarah and John, I'll go with you, Sarah, first. You'd like to comment?
Yeah, I think this can segue perhaps into the next comment, but certainly the idea of having an explicit reference to the right to a clean, healthy, and sustainable environment is on the table, I think, and is hugely important. For a number of reasons, but one of which is because of what else is in the UN General Assembly Declaration, which includes reference to recognition of the importance of procedural environmental rights in the 2018 Framework Principles on Human Rights and the Environment. A lot of really good stuff in that, but also there's also reference again in the UN Declaration recognizing the right to the UN Guiding Principles on Business and Human Rights, and that adds a whole other dimension which should perhaps be explicitly referenced in the treaty. But even if they're not, comes in if the UN General Assembly or the recognition of the right to a clean, healthy, and sustainable environment is in. So I think, from my perspective, I would get that in on some level, and then that could lead to, ideally those ideas informing the structure of the treaty. I completely agree with the procedural points that were made. Yeah, I'll stop there.
Thanks, Sarah. John, would you like to add on this?
I would just add very briefly, I think all these points are great points. The one sort of thing that I would just continue to reiterate, and again, I'm not trying to sound like a shill for industry here, but we are working within kind of the realities of the economic system, the sort of socio-cultural system that we do live in. And I just want to be thoughtful that any final treaty language is mindful of the practicalities and the realities of the consumer society that we do live in, and the fact that some of the plastic usages have enabled kind of much more affordable solutions for people, and that is a reality of what sort of, and so it's kind of a double-edged sword. I recognize that the global south is severely impacted by plastics waste. There's communities that are severely impacted by some of the chemicals issues that we've talked about. However, the same sort of drawbacks of plastics also lead to the benefits of plastic, which is something that I think just needs to be thoughtfully considered, so that we're not taking too blunt of an approach to sort of curtailing something that has, in some ways, enabled a lot of societal progress over years. Now, I'm not saying that that's not without its own issues, but I just want to be mindful of that dynamic. And I certainly think that you're probably hearing that from the folks who are representing industry within the discussions and the negotiations. And certainly, I'm not trying to just parrot what they're saying, but I think that that's the perspective that you're going to get from private industry, is that this needs to be practical. It can be super theoretical. It can be very great to consider all of these various constituencies, but we also need to think about the practicalities of it. And so I just want to kind of reemphasize that.
Mm-hmm. Oh, it's a huge part of it. And, it's definitely going to shape how this is framed. And I mean, one of the big challenges is how do we change society to so that the consumers will accept alternatives, will not be demanding all this instant throwaway stuff, right? I mean, there's a lot of societal change that has to go with that, and who leads that? That's the challenge, right? Whether it's industry, society, NGOs, governments, it's very complex. So this is not, it's going to be a snowball. I don't think it's going to happen all at once. Okay, we still have quite a few questions. The next one is specifically on the issue of business and human rights. So let's dive into that. The question is, what are the business and human rights dimensions involved in drafting a binding plastic pollution treaty? I know we've discussed some of them, so maybe we can shorten a bit of this, but how should the treaty deal with the problems of greenwashing by private and public sector actors, and really make progress on these issues? So I'm going to start off with Sarah, then to John, and everyone else is welcome to jump in.
Great.
Go ahead.
I feel like I have to just, as a follow-up to what was just said, remind people who probably don't know that the OECD guidelines for multinational enterprises on responsible business conduct have a chapter on businesses talking to consumers. And it includes the importance of business talking to consumers about the impacts of the products that they're selling to them, including the environmental dimensions. There's tons of stuff in the OECD guidelines, particularly the new 2023 version, that actually speak to exactly the challenges that are here, except governments aren't taking them as seriously as they should, and businesses aren't either. But that's an aside, but just to say we actually have the tools, we're just not using them. And it is, there's reference here to the idea of just transition, but many people are talking about just transformation as what's really needed, which includes real serious changes to consumer society, and that's going to take a lot of effort, by a lot, but we have the tools. The business and human rights piece is a huge piece of that. The UN Guiding Principles on Business and Human Rights from 2011 have a lot to say about duties of states, but also responsibilities of businesses, because the understanding is that states do violate rights, and we should expect that. And when that happens, businesses are not off the hook. Businesses are supposed to have human rights policies, engage in human rights due diligence, and they're also supposed to step up and remedy or contribute to remedy in human rights harms that they have caused or to which they've contributed. So I think if we think about what that might mean for even just the structure of a treaty, one of the things that is fairly absent in far too many environmental, multilateral environmental treaties is serious attention to remedy for harm. And whether that comes in through a business and human rights lens or in another way, I think what I hope this treaty will not do is replicate what we have in the climate regime, which is a regime that essentially has focused so much on mitigation, completely ignored loss and damage until, it's sort of at the last minute, and then is only offering something to a small group, but has essentially built a regime of irresponsibility, because the idea that the conduct that's trying to be addressed actually causes harm is almost erased from the structure of the treaty. Hopefully that's not going to happen in the plastics treaty, but it could. And I think this goes into the greenwashing sort of thing, right? The climate regime, by being set up with this idea of net zero, creates a really ripe situation for greenwashing, because companies can say, well, they don't actually have to reduce their emissions, they can just net their emissions. And I certainly, in the work that I was doing on the human rights-based approach to the plastics value chain, the idea of plastic credits was sort of being floated, and this links to some ideas of extended producer responsibility, which could be done well or done poorly. But I know there's a lot more that could be said, but I'll sort of stop there, and just to say, I think that just thinking through a business and human rights lens can give you ideas on what the potential gaps are, what the potential solutions are, and certainly makes me acutely aware that treaties, treaties are not magic solutions. You can have good things in treaties. You can also have very problematic things baked into treaties, and hopefully that won't happen this time.
Thanks for that. One of the issues that I ponder is we have so many human rights and business guidelines. They proliferate everywhere. But there's nothing really binding. It's you have to have something under domestic law to make it binding. And more proliferation on plastic pollution in that same vein might not be that helpful. I'd like to
But you
see
could say exactly the same thing about treaties. What's the Paris Agreement, right? Like implementation of climate obligations is, no better, quite frankly, than implementation of business responsibilities. It's just nobody wants to actually say that.
True. John, do you have some comments on this?
Certainly. No, I think you made very valid points, Sarah. And what I would say from kind of the private industry perspective is no company in their right mind would go off and unilaterally do something that they're not required to do, and they're looking to national laws and so I deal with my clients all the time who are like, okay, I want to comply with the law. There's all of these sort of transnational sort of statements or obligations out there. That's great. What do I have to do under the laws of the states that I'm operating in? And full stop. And because there's a million sort of obligations, and it feels for private industry that there are all of these burdens. And so unless there are national or state level laws that are dictating certain behaviors, you're just not going to get that, because no company is going to want to add on additional things that might not resonate with their customers, frankly, and which is driving a lot of the behavior here. I'm not saying it's a good thing or a bad thing. I'm just saying that that's how it is. And I would say that industry feels really overwhelmed with regulations and compliance, and it's extremely costly. And you have to have and you have in-house lawyers, and you have your outside lawyers, and they're all trying to make sense of the legal obligations that they need to comply with, and that causes challenges for them. I see you have your hand up, Sarah, so I'll let you respond.
I just have to say very quickly, to me, it's really, really important not to engage with clients. This, you can say this as an academic, right? But I think the mistake is to say that there is a bright line distinction between laws the government passes and this other voluntary stuff. It's not voluntary. It's potentially legally relevant. And we've seen that with the RDS case as an example, the Shell case in the Dutch courts. It is possible for ostensibly voluntary things to be referred to in legal actions against companies, and lawyers advising companies need to, and advocates who are talking about this stuff need to stop undermining the normative weight of these ostensibly voluntary things, because they are standards, and standards matter when it comes to due diligence, when it comes to standard of care, et cetera, et cetera. So sorry, I can rant about that for a long time because it's, I feel strongly about it.
Yeah, no, I think it's a very legitimate perspective. But what I would say is, within sort of the private industry perspective, is they will do what they have to do, not what they may have to do. And that's one of the challenges, because doing something in advance of being obligated to do it, or being sort of obligated to do it indirectly, even if it's not legal, but it's a reputational issue, or a customer says they're going to stop doing business with you if you aren't doing a certain thing. Those are kind of the soft levers that really drive the behavior. And so I just, having kind of lived within companies for a number of years, the practicalities of how these decisions get made and how you can justify lowering your cost margin to your CFO when you don't actually have to do it, technically, legally speaking, even though you're probably going to need to do it in 6 months, he'll wait till 6 months from now. And that's just the practicalities of working within these organizations. So I think those are super valid points. And I just want to just make one point on greenwashing, because this is an area that I advise a lot of my clients on. With so much voluntary disclosure kind of driving things, there's a lot of BS that's being put out there. Like, let's just be honest. And I do think that that's a really important thing for either this treaty or just any international obligations as they're being developed is just the recognition that if left to their own devices, private industry will say what they want to be heard, not necessarily what is accurate. And so, you know, it's very incumbent as we kind of think about these things, and whether that's even just statements like something is recyclable when in reality there's no recycling infrastructure. You know, having come from a CPG company, you know, we were sued and it's still subject to a lawsuit just from having the Chasing Arrows logo on a bottle. That was viewed as a claim to consumers that this was recyclable when in fact, I don't know, you probably know the data better than I do, 5 to 10% of materials actually get recycled in certain jurisdictions. Those types of things, I think, are getting sort of pushed back. I think rightfully so. For instance, the EPA is moving away from the Chasing Arrows logo because it's been perceived as a guilt-free purchase option for people, and that's probably not how it should be thought about. It should be thought about it, this is a resin identifier, full stop. I do agree that greenwashing is a really critical thing, and there needs to be a push on private industry to do more, because they will do the bare, I wouldn't say the bare minimum, but they will do as little as they can and be compliant with law and compliant with their customer obligations.
I would add, not just, but governments will also do that if it's in their interest.
Yeah.
You know, they will greenwash whatever their extractive industry is and say it's the most human rights compliant or the closest to net zero, or whatever they want to say, but it's part of, yeah, trying to assuage the concerns of the consumer or the public. Melissa, do you have a final comment on this topic of human rights in business and plastics?
Yeah, it's tied into what John was just saying, and I appreciate his candor there around, you know, what companies will say and the greenwashing question. But I also noted there was a question in the chat, or a comment in the chat, that I think is related to that. And you know, I wasn't going to say this comment because I'm wanting to keep the flow, but I think it's worth kind of highlighting what this person with Lynn Jacobs noted around the comment around what industry is putting out, that consumers want this, consumers need this. It's their lifestyle. How could they possibly do anything else? This is the way that it is, and this is what they want. And I think we have to acknowledge, as this commentator makes the point, is that consumers also are driven by what industry is putting out there. And so I think we need to be careful around the idea that it's all on the consumers, that this was potentially by design to get consumers to get onto this idea of a throwaway society, and the single-use nature that we live in. And so I think you have to be careful about when the industry is making claims around, oh, well, this is what consumers want, this is what consumers need, it's so convenient, how could we possibly get away from it? When arguably this was something that was done by design so that, you know, plastic could be produced. They could find new uses for fossil fuels that had glutted the system after the world wars. And so I think we just have to be careful in how we frame these things, because it makes it feel like it's impossible to make the change if it's like people will not know what to do with themselves. People industry has played a role in getting people hooked on plastic and the single-use throwaway culture. And so just like we have to be careful around greenwashing when it comes to claims around alternatives or what their products can or can't do, how recyclable, how compostable, we also have to pause when we hear claims around, you know, consumers can't do without this, consumers want this. There's a lot of stats out there right now and polls showing that a large swath of people around the world, including Canadians, want action on plastics. They don't want this in their bodies. They don't want this in their environment. It is a human health and it's a human rights issue that people want addressed.
Thanks for that, Melissa. Sabah.
Yeah, just quickly, like on the point of industry creating demand, I mean, we're seeing this live around the venue with the ads popping up from different plastics industries, right? Around the streets. There's a huge marketing. There's so much money, right? Billions of dollars that go into creating that demand. I have a daughter, you know, cosmetics, for instance. There's so many plastics that are wrapped in cosmetics. We see how much that's marketed to young women. So I think that, you know, we're only talking about partial sort of aspect of this whole affair, which is really that industry has so much financial power and we can't meet that same, I guess, reach when it comes to marketing, when it comes to reaching younger generations and convincing people that they need something. Furthermore, I think that really ultimately this is about moving out of our social reality that we live in. This, we mentioned I think John mentioned the sociocultural reality. Well, in Canada, our sociocultural reality is that we live largely on unceded Indigenous territory and in an era of reconciliation. So that is what we have to take into consideration when we're negotiating this treaty. And I'll leave it there. Thanks.
Thanks, Sabat. Yeah, need for change, right? Sarah, last comment on this one, because I'd like to move to the next question.
Absolutely. This is just a comment that I learned about some studies that have been done with communities, and I'm thinking there was one done with the Sami community on what were people doing before plastics were being used for certain things. And I think the point here is that sometimes there's a tendency to see the approach needed in the treaty, like to move away from plastics, we need industry to design alternatives to the plastics. But actually, there's also a really big piece about recovering lost knowledge about what was done before plastics. And I think that relates again to the importance of respect for Indigenous knowledge and other. Yeah, thanks.
Thanks, Sarah. Okay, we have a question now on issues of accountability and enforceability within the treaty. I'm not sure which of you would like to deal with that. So how should the treaty deal with issues of accountability and enforcement, reporting, complaints, dispute settlement mechanisms, etc.? We were going to have Alexandra lead off on that, but she got called away. So is there anyone who would like to comment on the question of accountability, or we could move right into the issue of implementation measures, if you like? Any takers on that? Okay, why don't we move to the next?
I definitely have a lot to say on accountability. I just didn't want to
Go for
get
it.
all those ways. But yeah, I think accountability is one of the pieces that's most important in the international space, and recognizing that, accountability enforcement is definitely more challenging in the international space. But I think, when it comes to the conversations around national plans and reporting thereunder, I think it's really important that this treaty makes it really clear that we're not going to take the approach that we did with the climate change convention, where we just, we have parties saying, well, we'll do our national determined contributions. We kind of get to determine for ourselves on a discretionary basis what our contributions to reducing emissions are going to be, and creating these more binding targets, and having national plans setting out how they are going to meet those targets, and then having regular reporting and making it publicly available about whether or not they're meeting their targets, I think is really important. And, talking about compliance mechanisms, there are ways to have a compliance committee that has oversight, that can hear complaints, and can take action in cases of non-compliance, whether it's financial, technical transfers, issues around trade. You can have trade sanctions if you really need to. So when I talk about accountability, I think that stuff gets lost in the conversation sometimes. The lawyers probably in the room are the only ones interested in that, but if you're going to have an effective treaty, those are some of the provisions that I think are really important to think through and make sure that they're included.
Is there anyone else who'd like to comment on that? Maybe I could put it as a different question for you, Sabat. You talked about other multilateral environmental agreements, and certainly with this plastic pollution discussion, there's a lot of science involved in it, and there has to be common understanding of the science and common development of the science so that you can have reporting, right? The compliance is often related to the science. Do you have any thoughts about that? Is it similar to other treaties, or is this unusual in this particular treaty?
Well, I think that for sure this treaty would have to have some sort of scientific review committee, especially if, chemicals of concern are to be listed, polymers of concern, also specific products. So there is there has to be several committees, or I mean, I mentioned earlier, my points on compliance and on complaint mechanisms as well. But in addition to that, I think it's important to point out that the Inuit Circumpolar Council, for instance, earlier this week, what they are advocating for is a mechanism to really monitor the human rights impacts of the treaty, or the violations of human rights coming out from states, actions or inactions with respect to their treaty obligations. And what they envisioned was a role for the Special Rapporteur on Human Rights, who would report out, and he would be counseled, though, or she, by a committee of Indigenous advisors, right? And so that's really interesting. It's a way to bring in human rights, but also to be creating an advisory council that has that Indigenous knowledge. I know that, under the NAFTA Commission for Environmental Cooperation, they've created an expert group. There's a civil society expert group, and there's also the traditional ecological knowledge experts group. So I think that we do have to look at different models, how Indigenous advisory councils can come in to inform the compliance processes. But again, I'll go back to my first point about membership in a body, decision-making and whatnot. There's no reason that observers or Indigenous peoples organizations, should not have full decision-making rights when it comes to, listing chemicals and such, because we're seeing under the Rotterdam Convention that it's extremely difficult, because states will not, be very visionary in that sense. And I think that we need that push that from non-state parties that have interests, to give them space in those compliance mechanisms. I think I'll leave it there.
Okay, great. Some interesting ideas. And also, I guess the national governments will play a role in listing these dangerous polymers, et cetera, and keeping an eye on them, and then reporting on that. That'll be a piece of the gathering data on what the status of progress is on this issue. All right, let's move to the next question, the last substantive question, and that is, what implementation mechanisms are needed to address such a complex challenge as global plastic pollution? We started talking a little bit about it. So, for example, remediation mechanisms, funding, technology transfer mechanisms, scientific and technical research, to back up the treaty and developments, stock taking, that's something we saw in the Paris Agreement, some sort of stock taking where you measure how you're doing, and then you see whether you can ramp up your ambitions. Is that something? Mechanisms for transition and other oversight mechanisms. So I would like to start off with Irina, but I'd like to hear from all of you on this. Over to you, Irina.
I'm happy to start us off, and of course we've already heard quite a bit about this because it connects to the previous question. So I'm not going to go into research, coordination mechanism, reporting, monitoring, compliance. For a moment on the notion of a dedicated international fund, because this is one of the obvious things that would give the agreement teeth in terms of enforcement. And in short, the idea there would be to impose, for instance, we can think of all kinds of forms of compulsory state contributions, of course, but also a cost like taxation mechanisms on manufacturers or traders or consumers, or possibly on states that fail to prevent the release of plastics into the environment, for example. And of course, this could require identifying the polluters responsible for these payment obligations, which can be challenging, as I've mentioned before, in terms of traceability and attribution. And the idea is that the proceeds could be dedicated not to compensating anyone in particular, but to mitigating and remediating, to stick to the theme that I've been emphasizing tonight on including removing plastic from the oceans. And the prospect of was noted by the INC. Can you still hear me?
Irina, Others,
Yes.
you seem to be freezing a little bit. Is
No,
anyone
apologies.
Is anyone
Yeah, I
noticing?
think,
Maybe, do you want to turn off your camera while you're speaking?
yeah,
Just, it might be
let's see
easy.
if that helps, of
Okay, thank
course.
you.
Hopefully this helps a little bit.
That's good.
Basically, I was just wrapping up to say, this notion is, I mean, this prospect of dedicated funds or a dedicated fund for instance, to clean up legacy plastic was noted by the INC Secretariat in its so-called Elements paper. A legacy fund, a so-called legacy fund, was also proposed in state submissions during the treaty discussions, for example, quite a while ago already by Ghana. This option is also mentioned in the INC 0 draft and the revised version that came late last year, for example, and talks about the option of a fund for specific purposes, such as addressing legacy plastic pollution. So funding sources and mechanisms in general have been a key topic throughout the treaty discussions, including a dedicated international fund for financing cleanup efforts on the high seas, and I think that's an important aspect of the negotiations.
Thanks very much, Irina. And if you want to turn your camera back on, that's great. We could hear you very well when you turned it off, though. So just remember that if we're running into problems again. Thanks so much.
Great.
Okay, and maybe I will now turn to Sarah.
I think I'm going to pass actually for the moment.
That's fine. Then who else do we have? Does anyone else wish to talk about this topic? John, did you have any? Oh, sorry, Sabah, I see your hand up.
Thanks. Yeah, I mean, I agree with Irina in terms of the funding that's critical, right? To get also nations on board that are from the global south. And I think that, even when it comes to information, I mean, we live in an open information age. We need to have transparency. Under the Basel Convention, there were efforts to create this mechanism where states would report on what kind of facilities, where are the facilities, they would identify the facilities that receive hazardous electronic waste, right? And there was so much opposition towards that because of confidential business information, because this idea that if I let you know where my recycling sites are, then it's going to affect my bottom line. Same thing with chemicals, we see that there's no information on chemicals because it's covered up because of the confidential business information. So I think that we should take that into consideration. We need to use the fact that we live in this great information age and, also bring it into here. There could be clearinghouse mechanisms. Earlier this week, Canada introduced its registry, right, to track polymers that are coming in. Manufacturers would have to disclose what polymer they're making and what quantities, how much they're exporting and importing. That's a first step. And there's no reason that we can't have these kinds of mechanisms on chemicals and plastics also, and to have that open data. This is really key. Artificial intelligence too, we have to think about that. Like how can we use AI in ways that we can create more equity and transparency and use it. So I think that there's much like imagination that we can actually put to implementation, but I think there is an obstacle, right, because of where the protection of corporate rights can come in the way of that.
I guess in the past, people assumed that plastics were safe, and so they didn't care to know. But now with the science developing, showing the dangers and how much they're getting into our bodies and the whole food chain, we're realizing that it is something we need to know about. And so the fact that the Canadian government has recently announced this new registry suggests that it is possible to do it, that it's not going to be too onerous from the point of view of secret business information or intellectual property and that type of thing. So it's a promising sign. I don't know if there are going to be other issues related to that will come up, but yeah, it's certainly a good step. Is there anyone else who'd like to comment? Melissa, did you want to make a comment on mechanisms? No? You're good? Okay. John, do you have any thoughts?
Yeah, I mean, if I could just address one of the points there. I mean, I agree that, you know, having like a clearinghouse of additional information would be very important. But I also just want to acknowledge at least the perception within companies, because I have sat in a reporting role in companies. This is potentially just another reporting burden on us. And does that create decision useful information for whoever needs to see that information? And that's something that I think is the reality within private industry is there feels like death by 1,000 regulatory cuts. And I know that they certainly, corporations have a loud megaphone in a lot of things, and I don't dispute that, but there's certainly a perception that this is just more burden for doing business, and it just makes things harder, and it makes things less viable to, you know, produce whatever we're doing for society. I also wanted to just quickly acknowledge a question that came in the Q&A around sort of the fact that there's been a demand creation from industry, and I acknowledge that. I mean, that's basically what marketers do. They create consumer pull, and then they sell them what they told them that they want. And that is clearly the case. What I would also say, though, is, you know, having lived through, you know, I worked with my chief sustainability officer. We did a lot of test and learns on different business models, including more circular solutions, more kind of milkman style models for a lot of things. Refillables, you know, you can take your container back to the store and refill it there, or there's different ways to do it. And not to say that, you know, at scale, maybe that could work. The challenge that we experienced is doing those kind of one-off things. It's hard to get the critical mass to make sense, to change the consumer behavior, or to change the behavior of the retailer who's like, I'm not going to put a refill station in my retail location. All of those things, like you almost kind of need a collective consensus to move to that new reality, because individually nobody's going to do it, because they try to do it and then they're going to be penalized by the market, and so they're not going to be incentivized to do it. So you almost you have a collective action problem that I think needs to be addressed. And so to add to kind of the implementation discussion and some of the points in your question, I would just note that a lot of these you know, manufacturers, they have a lot of data, and so that if we're talking about sort of including that science into it, I certainly think it's going to be slanted data. To be clear, they're self-interested for sure, but there has been a lot of thinking into behavior change and what that would look like, and what the cost would be, and what the adoption of all of that would be. And so I just want to be mindful that as we're implementing these new laws, the practicalities of how this would play out, there's thinking that's been a lot of thinking that's been done on it, and you know, I just want to make sure that we are considering the business practicalities, because for better for worse, that drives a lot of the conversation, and it still will. And so it's just something that I want to, you know, have folks kind of thinking through as we move this forward.
I see that there's a question in the chat, and that I don't think we picked up. Thanks for taking that one, John. Here's another one. If the like-minded states and possibly others ultimately aren't willing to accept a treaty that has strong human rights provisions, addresses primary production, creates strong accountability mechanisms, and includes many of the other ambitious provisions that the panelists support, would panelists choose a strong treaty with low participation or a weaker treaty with broader participation? What a tough question we get from our audience. That is a very good question. And it is one that I think it's worth mentioning, because this is definitely on the table, isn't it? It's the difference between a consensus document that may bring everyone together around something much weaker, or an ambitious document that divides everybody and maybe does not get enforced, but sets a high standard. Anyway, I see 2 hands up. So I'm going to go to Melissa. Everyone has to be conscious of time, because we're going to end at 6. But if you could bring this question into your response too, that'd be great. And then over to Sabah and anyone else who wants to jump in on this. This will be kind of our lightning last round.
Sure, yeah, and I do have a hard stop on the hour. So I was originally going to respond to John's comment. And I just want to say about I guess I do have a comment on implementation after all. in terms of death by 1,000 cuts to the plastic industry. I really have a hard time feeling bad for the industry who's making billions of dollars, that they have to report on what they're doing to, human health and the environment. Like, industry needs to be transparent. They need to disclose how much they're producing, what is in the chemicals, what chemicals are in the plastic they're producing, and their impact. If they can't do that, then they shouldn't be allowed to operate. I'm much more concerned and feel a lot more sorry for the people who are being harmed, who are dying, for the other animals that are being impacted and dying. And I just, for me, if they cannot report on what they're doing and disclose, then they should not be operating. On the point of the treaty, I would say, obviously, I would like to see a strong treaty with, I guess, less sign-on. I guess I would say that if we could have a non-party trade provision in there, hopefully it would be more of an incentive for parties who are lower ambition to sign on, because then they will have trade implications. And yeah, and I'd also just mention around the consensus point that Una made is that the rules of procedure are an issue that aren't getting enough play, that we need to be looking at moving from consensus-based decision making to majority-based decision making for some of these pieces, because otherwise we're not going to see the progress we need, and the low ambition countries are going to make everybody have to drag their feet, and we're not going to get the strong provisions that we need. So I'm hoping that between the negotiations and the next one in South Korea, that the rules of procedure issue can be addressed, and we have a majority voting process so we can make progress toward a strong treaty.
Thanks, Melissa. Sabah?
Yeah, I was just going to respond on the non-party trade, non-party trade provisions, and that exists in the Basel Convention, for instance. And I just wanted to also recall that, I mean, the Montreal Protocol negotiated, in 5 years, 1987, 46 signatories at that time. Today, universally ratified treaty. And so, if we could do it then, I think that we can do it now. It's a major global public health problem, and there's no reason that we, can't replicate what was done under the Montreal Protocol. Thanks.
Is there anyone else who'd like to comment on this idea of trying to get everyone to hold hands and agree on something, or moving forward with ambition?
I can say I love Sabah's optimism and would love to endorse it and do, but have a lot of pessimist in my heart as well, which, I really hope that actually this can, and I really think it's super important that this be pulled off. I would not be happy with a weak version that can undermine future action, which is, I think, a risk.
Mm-hmm. Anyone else like to comment on this aspect? Which way you go? Well, I think it's obviously a question at the heart of this whole negotiation, and hopefully we're in good hands with the negotiators, that they will find some way to pull together an agreement that is something better than lowest common denominator, and that doesn't prejudice being more ambitious as we go forward. The Paris Agreement could be viewed as one of those, lowest common denominator agreements, but it had a kind of hortatory value as well, and it inspired more action. We're still dealing with the problems of climate change, though, so it's hard to know whether that is a safe bet to go that route either. So I don't think we have a final answer on that question, but is there anybody who'd like to is there any last thought you'd like to leave with the audience before we sign off? Very quickly, lightning round, 20 seconds each or so.
I'm happy to, I guess, just pick up on that, which is, of course, I'm speaking from Dublin, Ireland. I'm not at the plastic treaty negotiations. I'm really, really interested in this area, but I do think it's really important to, we don't put all the eggs in the basket of the treaty. We're going to get what we get. Hopefully it's going to be something really good. Hopefully it's going to be something that's going to be well ratified, come into force, solve the problem. But if it's not, we don't stop, right? We still have to address this problem, and we'll figure out how to do it. And there's lots of other things we can and should do.
Thanks. Sabah?
I'll just add to that, with the experience of the Paris Agreement and climate change, if we don't do it, if governments don't do it, then it'll be done through litigation. And there is scientific evidence, public health science pointing to the aspects. So better a treaty than a slew of, wave of plastics litigation coming through. Thanks.
Any other thoughts, John? Did you want
I'll just echo that. I mean, that's the reality that I think is facing private industry, is if this isn't regulated, it is going to be solved through litigation, which is messy, complicated, very expensive, and something that industry doesn't want to deal with. So in some ways, more painful kind of regulations that have clear rules are better than messy, long, drawn out, complicated litigation as well. So I would certainly echo that. I would, just kind of put my industry hat back on and say, wherever this ultimately lands, I think the desire would be for it to be as pragmatic as possible and realistic about what the costs and benefits are from just the way that society behaves. And I recognize that probably needs to change, but it is what it is now. And so I just want to be thoughtful of how this plays out reflects the reality and the business reality, because that's certainly what's driving a lot of behavior change.
Thanks, John. Melissa, last 20
I would
seconds.
just say put people first in this treaty. I'll be less worried about the business reality or the business case and more about the human health, human rights, Indigenous rights case when we're thinking about this treaty, and not thinking about where we are now, but where we need to be, and not feel like we can't move forward and we have to be stuck in the status quo when it's just too hard, because our health and our humanity really depend on us addressing plastic pollution in a meaningful way.
Thanks. Irina, would you like to say a last word?
Yes, so very quickly, that I have emphasized that I think oceanic legacy plastic is something we shouldn't lose sight of in the upcoming treaty. There, I think we can build on the existing legal framework, build on state submissions in these discussions. The building blocks are already in place, and ensure we set out to connect to the previous question, a strong treaty with effective, concrete, specific provisions and mechanisms to deal with cleaning up plastic pollution in areas beyond national jurisdiction.
Yes. Yes. So if we could get the gyres under control, this would be a huge success, wouldn't it? Even though that's only a small part of the massive problem we're dealing with. Look, I'd like to say on behalf of everyone on this webinar, thank you very much to all of you. You've been excellent speakers, and you've provided so much useful information today. I thank the audience for your attention and your probing questions. Please follow ILA Canada and ILA on our respective websites and social media for our next events. You're most welcome to join the exciting and supportive international law community at ILA Canada. And please note that we provide free membership for students. So I wish you all a very pleasant evening, and all the best with the negotiations. Thanks so much for joining us. Bye-bye.
Thanks so much.
Thank you.
Thanks, Una.